Our job when we're working in the civil jurisdiction in litigation is to secure remedies for our clients via that process of litigation, which means that we find a cause of action that applies to their situation or their problem, we identify all of the elements of that cause of action, and then we locate enough admissible evidence of each of those elements of the cause of action such that the tribunal of fact, which will be a judge or a magistrate or a jury, is going to be persuaded of each element on the balance of probabilities. So all we're interested in as litigators are those facts which are going to be able to pass through the filter of the rules of evidence. Everything else is extraneous. And sometimes clients don't appreciate what that means. Sometimes clients think that a court is just a place where you have arguments and you bring up every argument that you think is personally relevant. They think that anything that they've seen or heard or that they claim to know is something that they should be able to bring up in court and have heard. But if that was the case, of course, then a courtroom would just be a glorified marketplace for gossip and innuendo, which hearsay, as we'll see, tends to be. And litigation would be an endless quagmire, a quagmire of dribble. I'm sure you'll remember from your reading of the classic Dickens novel Bleak House what used to happen before we had strict rules of procedure and of evidence in courts. Courts were indeed quagmires in Victorian times, and in that novel, the matter of Jarndyce and Jarndyce had been dragging on for so many years that nobody involved in the case could even remember what the case had originally been about. And at one point, a character, Uncle Tom Jarndyce, one of the lawyers, becomes so confused and frustrated at the complexity of the matter that he explodes in a sort of a cloud of spontaneous human combustion. And one of the current lawyers, Mr. Jarndyce, describes it in this way. Let's have a look, a little extract from the book. He says, "Of course, Esther, you don't understand this chancery business." And of course I shook my head. "I don't know who does," he returned. "The lawyers have twisted it into such a state of bedevilment that the original merits of the case have long disappeared from the face of the earth. It's about a will, and the trust's under a will, or it was once. It's about nothing but costs now. We're always appearing and disappearing and swearing and interrogating, filing and cross-filing, arguing and sealing and motioning and referring and reporting and revolving around the Lord Chancellor and all his satellites, and equitably waltzing ourselves off to dusty death about costs. That's the great question. All the rest, by some extraordinary means, has melted away." "But it was, sir," I said, to bring him back, for he'd begun to rub his head, "about a will." "Why, yes, it was about a will, when it was about anything," he returned. But now we've got this powerful filter of admissibility and judicial discretion to limit what facts and what assertions can be led in court, all right? So you can't just call a witness in court and let them just spew out everything it is that they want to say that they think's relevant to the matter. Okay, we've got to put it through a filter of evidence, and a lot of the things that people would like to say in a court is not going to be admitted. And it's that filter that we're learning about in LLB 303. And we've seen it works like this, all right? So have a look at the screen here and we'll see where we're up to in the evidence filter. First of all, we list the elements of the cause of action or of the alleged offence, if we're talking about crime. For any piece of evidence, we determine whether it's being led as oral evidence, as documentary evidence, or as a piece of real evidence. And then we ask whether that piece of evidence, if it's accepted by the tribunal of fact, is something which would make it more probable than not that one of the elements of the cause of action or of the offence is true. In other words, is the piece of evidence relevant? If it is relevant, does that piece of evidence breach one of the exclusionary rules that we've developed to keep the dribble out? In other words, for example, is it hearsay or is it just mere opinion, someone's opinion, rather than the direct observation of the witness currently appearing in the court? Because that's what we want, the direct observation, not the interpretation or some spin of the witness. If it does breach one of those exclusionary doctrines, then it's prima facie inadmissible unless a statutory or a common law exemption applies. So is there some provision in a statute or some common law rule we can point to which says even though it is hearsay, it's nevertheless admissible because of, and then point to the rule and the authority. If an exception does apply, then it's admissible, but it will only then be admitted if it's not subjected to one of those two discretions we know that a trial judge has to exclude admissible evidence on the grounds of the fairness or the public policy discretion. A judge, remember, has no discretion to admit evidence which is not admissible. And then, if the evidence is admissible and it's admitted by the judge, we then need the jury to give it sufficient weight for it to be persuasive. And over the next 2 weeks, we're going to look at the major exclusionary doctrine of hearsay and at the statutory and the common law exceptions which might apply to make evidence which is hearsay and therefore prima facie inadmissible admissible. Properly understanding the rules of hearsay and internalising them is to learn to think about them in connection with factual scenarios first. That means hearing about and reading the iconic cases, the leading cases, and there are 3 or 4 that I'll talk about in week 7 and 3 or 4 in week 8. If you just try to learn the rules in the abstract and you rely on having 1 or 2 facts of the cases at the back of your mind, it's much more difficult to get the hang of it. The real knack to dealing with hearsay is being able to put the precise piece of evidence that you're dealing with into the factual context that it comes from. So you're always looking for the exact words or the exact action that you say forms the piece of evidence. And you'll see what I mean when we start going through the cases. So my main piece of evidence to you is to pay closer attention than usual to the facts and the narrative of the story of the cases that you're reading or that you're listening to when you're studying hearsay. On the slide there you can see there's a brief outline of how evidence which is potentially subject to exclusion due to hearsay should be dealt with. First of all, identify precisely what piece of evidence you're referring to. It could be something which was spoken or uttered, it could be something contained in a document, or it could be a person's conduct. What you're looking for is some item which is representative of a statement, some item which you say makes an assertion of fact, and then you decide whether whatever is asserted by that statement is relevant to a fact in issue. If it is relevant, then decide whether that spoken phrase or the document or the behaviour and what it asserts is either hearsay or original evidence. If it's original evidence, then the item's admissible as evidence of both the fact and the assertion that was made by it. All right, so it's evidence of the fact that that statement was made and as evidence of the truth of what that statement asserts. If it's hearsay, then it's non-admissible, unless you can demonstrate that it comes within either one of those common law exclusionary doctrines or it's subject to a statutory exception. Let's consider first of all then what hearsay is. At the most fundamental level, of course, it's just a combination of hear and say. I heard somebody else say something, now I want to repeat in court what it is that I heard them say while I'm giving evidence under oath. All right, so a person said something, I heard them say it, they're not repeating in court what they said, I'm repeating what I heard them say, so it's second hand. And an example could be a fact in issue might be whether a defamatory statement was published by way of somebody speaking the statement. And now we've got a witness who was in the room when that alleged defamatory statement was made by the defendant. So can the witness tell the court what they heard the defendant say or not? All right, so the alleged piece of defamation that a person spoke, who's now the defendant, can we get a witness to come into court and say, yes, I heard them say X? Or a fact in issue in a negligence matter might be whether a driver was driving without due care and attention. We might have a witness, let's say, whose wife was outside at the material time and she saw the car being driven. She comes home and she tells her husband that it was travelling all over the road at high speed. And now the plaintiff wants to call the husband to testify what his wife said to him about the car being driven erratically, as evidence that the car was in fact being driven without the requisite care. Okay, so the wife comes home, says to the husband, gosh, there was a car down the road driving all over the show, and now the plaintiff's lawyer wants to bring the husband in so he can say, yeah, my wife told me all about that car and how dangerously it was being driven. Right? My wife told me that she saw and whatever it is. And he wants to repeat that in the court. Well, clearly that's relevant evidence. It's relevant. I mean, in the ordinary case of things, it would be really interesting to hear what his wife told him. But we're talking about a court. Can he repeat what his wife said in a court? What would be wrong with that? What would be wrong with any of those things being repeated in court? Why would we need a rule to prevent the court from hearing that kind of evidence? Well, we might want to exclude it if we think that it would be somehow unfair to the defendant to let it be heard in a legal sense, or if we believe that even though it's relevant, it's so unreliable as to be of virtually no weight. And that's the cloud which really hangs over hearsay, the ugly spectre of unreliability. Perhaps the witness who wants to report his wife telling them that she saw the car driving all over the road is the employee of a man who was then injured by the defendant's car. All right, so he's potentially got a stake in the defendant losing the case. Perhaps the husband was drunk when his wife told him what she'd seen and he's remembering it incorrectly. Either way, if it's just the husband who's telling us what he claims his wife told him at that time, all right, he's telling us what he claims his wife told him that she saw. She's not there telling us directly, so we can't cross-examine her or make an assessment or a judgment of how reliable we think her evidence is. She'd be the witness we'd want to hear it from, all right? It's her evidence we want, not his, not the husband who's only giving us a second-hand version of events. And that's the whole problem we generally have with hearsay evidence, is that we consider it to be inherently unreliable, or at least less reliable than the evidence of the person who observed or saw or heard directly. There's no definition of hearsay in the Queensland Evidence Act, although you'll see mention of the hearsay rule, in inverted commas, in section 93 capital B in relation to one of the exceptions that we'll look at. So for the purposes of Queensland law, hearsay is within the contemplation, obviously, of the Queensland Evidence Act, but the meaning for it we take from the common law. There are some definitions of it there on the slide, and they're in the study guide as well. Cross-on evidence says that it's an assertion other than the one given by a person who's giving oral evidence in the proceedings that's inadmissible as evidence of any fact asserted. In Subramaniam's case that we'll look at, they talk about evidence of a statement that was made to a witness by a person who was not himself called as a witness in the court, may or may not be hearsay. It is hearsay and inadmissible when the object of the court hearing that evidence is to establish the truth of what's contained in the statement. So Subramanian is saying that an out-of-court statement, evidence of having heard that, will be inadmissible if the point in tendering it is to use it as evidence of the truth of the statement, whatever the words were. Walton's case, another one we'll look at, the hearsay rule applies only to out-of-court statements tendered for the purpose of directly proving that the facts are as asserted in the statement. Pollitt is another case we're going to look at in a little while. That says that the rule against hearsay excludes evidence of an out-of-court statement if tendered to prove the truth of the matter stated. So it all boils down to what your purpose is. Why do you want this witness to come into court and tell the jury about what he or she heard someone else say? Why are you trying to have admitted? Do you just want to prove that somebody said those words? And sometimes you do. Sometimes it's got to do with state of mind, all right? You're not interested in the actual words. You might want a witness to come in and say, yeah, I heard that person yelling their head off at the top of their voice and they were shrill and they were excited. You just want the jury to hear evidence that the person was excited or scared at the time, the person that's not in the court. You're not leading the evidence of what they said as truth of what the actual words mean in that case, or are you leading the statement as evidence of the truth of what it asserts? So let's think a little bit more deeply then about why we want to exclude hearsay, because very often it's not excluded these days. Generally, it's because, as I said, that great forensic power of cross-examination, that's the most important tool we have in trials and litigation. And this is why matters go to court. All right, as you probably know, most criminal matters end up not going to court trials. There's a plea of guilty or a plea bargain, and most civil matters settle before they go to trial. If they go to trial, the reason we want them there is for people to be cross-examined. The greatest strength of the adversarial trial system when we go to trial is this knack for getting people to tell the truth, because we put them in a formal courtroom, subject them to questioning by skilled advocates. It's going to be you in a few years, under threat of punishment if they're caught out knowingly misleading the court, which is perjury. All right, so they know they have to tell the truth. They've got a skilled advocate who asks just the right questions to delineate around the facts that this person is giving us. We can get to the truth. And you can only put a person under that pressure to tell the truth about what they saw and heard, and to assess their demeanour, how confident and how truthful do they look, if they're present in the court. We don't want to have to settle for hearing what they may or may not have told some other person about what they saw and heard, because second-hand information, as all of us would be aware, is almost always less accurate than first-hand information. First-hand information from the horse's mouth, best evidence of what happened. It's just common sense. So common law judges have always been very wary of admitting inferior evidence when better evidence or the best evidence should be available, right? That's a general common law rule, that judges will usually want the best evidence that's available and won't settle for inferior evidence, and hearsay is a sort of a subcategory of that. So the rule against hearsay is based on that common sense assumption that we should treat second-hand reports as being inherently unreliable, suspicious about why isn't the person themselves here delivering this information, unless we've got some good reason to think otherwise. All right, and that's what the exceptions are about. The exceptions to hearsay are all about countering that inherent unreliability and making them reliable. The usual common law explanation for this rationale of inherent unreliability comes from the case of Tepper and the Crown. You don't need to read it, just listen to what I've got to say about it. In that case, the Crown was pursuing a charge of arson against a shop owner, all right? So the charge was that he'd burnt down his own shop to collect the insurance, wasn't making enough money, get the insurance and go off and start something else. And they wanted to get into evidence something which a third party had said to Tepper at about the time of the arson, all right? So, in fact, what it was a statement which a policeman claimed to have heard by a woman who was watching in the crowd about 25 minutes after the blaze had started in the shop. She was watching the fire. A car drove past her. She called out to the driver, "Hey, Tepper, your place is burning down and you're driving away from the fire." And the driver, of course, just kept driving, the implication being that Tepper had set fire to his own house and was running away to avoid detection, the fact that he just ignored this statement that was put to him. So that evidence met the test of relevance, of course. It was relevant to whether he'd set the fire. If you were, just wanting to know, did he set the fire himself, and someone said to you, "Yeah, I called out to him, why are you driving away when your shop's on fire?" That would be interesting to know. But let's think about it. It was an out-of-court assertion, all right? So this was a statement that was made by someone who wasn't in the court herself. So it wasn't the woman there saying, I called out to Tepper. So it's vulnerable to the objection from the defence as hearsay, because they're getting a police officer to claim that he heard a woman say that to Tepper and that he'd ignored her. So the Crown wanted to tender that evidence of what a person in the Crown had said as evidence of the truth of what she had said, of what she'd expressly asserted, hey Tepper, all right, so the express truth, I'm talking to a person whose name is Tepper, and what the statement impliedly asserts, that he was running away from the fire because he didn't want to be discovered at the scene. You know, why are you driving away? And the fact that he ignores it, that, you know, the implied assertion of that in statement is he's driving away from his fire, as, you know, sort of a consciousness of guilt. And the Privy Council ended up saying that it was clearly hearsay. It was evidence of an out-of-court statement, and the only reason why they wanted to lead evidence for the policeman to come into court and say he'd heard it was the evidence of the truth of what that statement asserted, the evidence of the truth of what was meant by those words that she'd uttered. So we take two things from that case. First, both express and implied assertions can be subject to the rule against hearsay. Why implied assertion? Because she didn't say to him, hey, you're running away from the fire because you said it to get your insurance. She'd said to him, her express words were, why are you driving away from the fire? All right, but that implies you're driving away from it because you said it. Secondly, it's a good statement of the rationale for the rule. It's not the best evidence, and it's not delivered on oath. All right, so she's not swearing that she made that statement, and that would be the best evidence. The truthful and the accuracy of the person whose words are spoken to by another witness can't be tested, obviously, by cross-examination, and the light which his demeanour would throw, or in this case her demeanour would throw on her testimony, is lost. Did she really make that statement to Tepper? You know, so did she identify someone that she thought was Tepper? Did she really say those words, and what were his reaction? All we've got is this policeman's second-hand report. What would be really interesting would be to get the woman in court and to see how she stands up when we start testing her evidence under cross-examination.